Let me talk to the leader, Alexander Afenyo-Markin.
Yes, he's joined us on the line.
MP for Futu, leader of government business. Until yesterday's judgment or decision, he was the majority leader. I'm not even sure if he agrees that he's the minority leader. I don't even know. Honorable Afenyo-Markin, are you still the majority leader or are you now the minority leader?
Bernard, with the greatest respect and all due respect to you, I don't think that Mr. Speaker himself made that pronouncement, and I don't want us to fall into unnecessary traps. Even when, in the midst of the chaos he created, he still addressed me as majority leader, and he addressed Atu-Forson as minority leader. In spite of the mistakes he himself was doing, he knew that there were areas he couldn't go to. So let's go straight to the point without creating unnecessary confusion. So please address me.
Fair enough. What I wanted to understand, the implication of his ruling.
Don't let us go. He's created his own mischief, but don't let us fall for it.
No. That's actually where we are. That's the issue. The issue is that the Speaker of the Parliament has, based on his, I don't want to call it a ruling or judgment, yesterday.
He says, wait, in his ruling,
yes,
he says he has declared the seat vacant.
Yes.
He stopped there.
Yes.
He didn't go further by saying, he didn't go further to give consequential order. He said, he has declared the seat vacant. This is where he ended.
Yes, and I'm saying that by declaring the seats vacant, it means that the 4 members of Parliament have been removed from Parliament. Is that not what it means?
Well, if we want to do a full story, let me finish with a full story. As you may be well aware, we are already in court. At the time, he was making a ruling on a statement. And by the way, a speaker has no such mandate to make a ruling on a statement under Order 93. In our rules book, when a statement is made, let's make comment. And if Mr. Speaker, at the end of the comment, he wants to make consequential orders, he makes reference, he refers the thing to a committee. Order 93.6 is very clear. And we drew his attention to all of this. So he had no such power to make a ruling on a statement. It has never happened, and it is not part of our rules. If an applicant wants a matter to be determined, it comes by way of a motion. Now, one would also wonder why Mr. Speaker decided to set aside Haruna Idrisu's notice of motion for the matter to be determined. Bear in mind that in my response to Atu-Forson's statement, I drew the attention of Mr. Speaker, and indeed he was aware that I was with him in his office when Haruna brought his petition, which petition was to invoke his jurisdiction under the relevant rules to investigate the matter. I was copied, the minority leader was copied. Now, when somebody serves you a notice of a petition, your duty is to admit it or dismiss that. If you admit it, you refer it to a committee. And the committee's duty is to go through the whole motion. So, frankly speaking, I don't know what Mr. Speaker was up to, but he created this whole confusion, and I don't know to what end. Because Haruna Idrisu had an application before him. As we speak, the application, I don't know what has become of it, so he let it go. And even if under the 93 that Atu came under, he wanted to even refer the matter for further consideration, a committee was supposed to be set up. So it is all a matter of political football. They were just in a rush to create mischief. But some of these things you wouldn't to belabor.
But Honorable Afenyo, Mr. Babin had said on Tuesday that he was going to deliver a ruling on Thursday. So I think we heard him when he said this. Did you point out to him that he could not do that based on what you're telling me now? Because he actually announced that he would think about it for 2 days.
Is my witness. Mr. Bernard Avle, Hansard is my witness. Even yesterday, I continuously pointed it out to him. That's why he wanted to have a banter with me. And out of respect for him, I just left quiet because he's the last person I would want to have a banter with. He's an elderly person. We may disagree, but I have vowed that from the day I came on the seat, I said that practice where when a leader is upset over a matter, he would have a banter with speaker. I vowed never to do it because no matter what, that chair, no matter what, even if he errs, even if he does mischief, that chair must be respected. And that is what I did. And I didn't want to lose my cool.
Fair enough.
Mr. Baldwin was told that he couldn't do what he did. In fact, I directed service when he told the legal directorate not to receive the process. The bailiffs went there. They were serving the legal officers, and they told him that the bailiff that they should wait. They have to go and consult Mr. Speaker. They went to Mr. Speaker. When they came back, they said that they couldn't receive it. I went to Mr. Speaker to inquire, Mr. Speaker, why? What is going on here? My witness is Honorable Amwakwe Siama, the second deputy speaker. The two of us were in his office together. All right? I went to Mr. Speaker and said, Mr. Speaker, what is going on here? The court bailiff has come. The legal people are saying, Nanetewia and Wendy Yabua are saying that they have to come and consult you before they receive a court process. What is going on here? Then he explained to me that indeed they came to consult him because there is a circular from the Chief Justice regarding sanitizing service of court processes. And that the understanding they reached was that processes of court should be served on Parliament only on Mondays because Mondays are the days we don't sit. And that the legal department is supposed to receive all processes for and on behalf of Mr. Speaker. I said, okay. Then I went further by saying that, Mr. Speaker, but this matter is an urgent matter. It's an urgent matter that Harun Idrisu has filed. I have also filed for interpretation because clearly it's a matter that requires interpretation. And he agreed with me that yes, but then we should wait for the Monday. So in my presence, he called the Chief Justice to, have a discussion regarding the service of the process. He could not reach the Chief Justice. I called the Judicial Secretary because he asked me if I can get the Judicial Secretary so that we can get the Chief Justice to give directives. Now, the whole point was that if we are going to wait for Monday to serve the process, then you don't have to rush to go and give a ruling. That was the understanding we all had. If indeed we all want to act in good faith, we want to protect the democracy, and it isn't the case that somebody has an agenda to embarrass somebody to give an advantage to another person, then there was no need to rush to come and give a ruling or to even come and hear a matter. My understanding was that they would wait till the Monday, which is the supposed day agreed on for service to be effected. But then the next day on Wednesday, based on what he said, I became a bit apprehensive. And I said, no, under the law, plaintiff can direct service. So when the bailiffs came again, I went to the legal directorate and directed service. And they duly served, and then they notified Mr. Speaker that the process has been served on them. You remember that on the floor, he tried to bring that matter up, and I sought to clarify, but he wouldn't want any of that, so I had to back up. Now, let's put that aside. The essence of parliamentary practice is to give all parties an opportunity to be heard. That is why we have our rules. Now, the question that any reasonable man on the streets of Ghana should ask is, why the rush? Why did they set aside Harun Idrisu's petition, which is a proper motion? Why is it that mischievously, Atuforsen would have to now come out with a statement. He came under Order 93 and said he's making a statement. Because they realized that the Harun Idrisu route will not give them the solution that they wanted immediately. And soon thereafter, their flag bearer was on the campaign platform commenting on the ruling that, yes, they have it. You know, if we're really serious about our democracy, we can do better than this, and we should do better than we have done.
Let me understand what you took to the Supreme Court. What was your... Are you asking them to interpret the status of the four on the basis of the motion Haruna was supposed to have filed or the statement Atu made? What did you send to the Supreme Court?
All right. So my processes preceded Haruna's petition. However, it took roots from the intention that he had expressed on the campaign platform. So basically, this is what I said. Yeah, look, we have this provision under the Article 97, all right? And that these individuals, I did the three, because the three are the members of my caucus. So my plaint was basically that those three, although they have filed to become parliamentary candidates for the next election, currently, they still remain members of my caucus. They have the two, Suhum and Aguna West, have not resigned from the party. They have not written to me as a leader of the party in parliament to say that they are no more with us as a caucus. The independent candidate, who is the deputy speaker, second deputy speaker, has also not written to me to say that he is no more part of our caucus, although he has filed to contest as an MPP candidate for the next election. So I lay down those bare facts to also state in conclusion that none of them has crossed carpet. Now, what were my reliefs? My reliefs were to the effect that, one, that the Speaker of Parliament be restrained from making any declaration, which declaration would be as a result of an application from either any member of Parliament that those people, by virtue of their decision for the next election, they are cross-cutting. And two, that a declaration be made by the court to the effect that the fact that a person has filed a nomination for the next election on a different ticket other than the current ticket upon which that person entered parliament does not amount to the person crossing carpet. So in essence, these are the two key reliefs.
So, by the way, how different is this from what the MPP did to the same Andrew Esiama Amoako? Because in 2020, let me ask the question, then you answer, please. I remember that the party was unhappy that he had filed to be an independent candidate and wrote to Speaker Okwe complaining about that. And I remember that Okwe ruled that Mr. Esiama could no longer hold himself as an MP, if I'm mistaken. So what is the difference between the two situations?
All right. One, the party has not written a letter to the Speaker to make a complaint. That is the first thing. Two, Speaker Okwe is not a court. Granted, without admitting that there was an error in terms of precedent. Should we maintain or continue in that error? Three, the matter under 97, whether or not somebody qualifies to remain in parliament if he expresses an intent for future elections and a different ticket, is a matter for constitutional interpretation. Now again, the decision to declare vacancy, to declare a seat vacant, is governed by Article 99, which is also the jurisdiction of the High Court. Again, the Constitution itself anticipates that there could be situations where vacancies could arise. But it's quick to add that when it is 90 days to election, where such vacancy arises, there is no need for a by-election. There can be a by-election. In other words, what Mr. Bagwin, Right Honorable Speaker, did yesterday was more or less to deny people an opportunity to be represented. Again, what he did yesterday was to arrogate to himself the power of interpretation. Although in his words, during the supposed ruling, he claimed that he knows that he doesn't have the power to interpret the Constitution. But practically, impliedly, what he did was to make a declaration and interpret the Constitution, which is what he did. All right? But this is politics. Okay?
You're saying this is more politics than law because from the difference you just gave me.
What he did is it is politics.
No problem. What I'm saying is that the major difference between the two situations, based on what you've just told me, is the fact that in the 2020 situation, the NPP wrote to the speaker, but in the 2024 situation, the parties have not yet written to tell the speaker that this person has forfeited their membership. That's the major difference. But in terms of what...
That is the point.
But I'm saying that by respect of what Speaker Okoye did and what Speaker Bagwin have done, essentially is the same thing.
What I'm saying is, and let me make it very clear, I hold a view that under Article 97 of the Constitution, no speaker can make a pronouncement which pronouncement will amount to interpreting the Constitution. This is my very humble view, and I want to make it very clear.
And have you always had that view? Did you have that view when Speaker Okoye did that in 2020?
I am telling you
or it's
that
a new
this
view?
is my view.
No, I'm asking because the consistency is important. It's a principle, right? So are you saying that when it happened in 2020, you had that same view?
Bernard, respect. Before you say that, lay the foundation work. You can only say that if I had previously commented. Then you can now ask me whether or not I am being consistent.
But you didn't express a dissenting view at the time.
No.
You didn't express a dissenting view
I'm
at the time.
That, no. I am saying that it is my view. You know Parliament. You know Parliament well enough that we work in Parliament in caucus and through leadership. All right? It's part of the whipping system. I am a leader, and I make those pronouncements for and on behalf of colleagues. And I have the authority of the party to make certain pronouncements. If you are a backbencher, you don't go rabble-rousing all over the place. So don't let us go there.
No, but what I'm saying, it's not. You see, Honorable, it's not even about. This is not even about Afenyo-Markin.
So don't say whether or not.
No, the question is not. The question is not about you necessarily. The question is that in 2020,
you put a question to me.
Okay,
You ask me whether I'm being consistent. I'll say this is my opinion.
Yeah,
I've expressed an opinion that this matter of
no problem. Let's make progress.
A matter for interpretation.
What I'm seeking to ask is whether the MPP as a party saw anything wrong with what Speaker Okoye did at the time, for which now they are against what Speaker Babin is doing. Because as I'm pointing out to you stridently, with the exception of the trigger of the letter, essentially the same situation. So did the party see anything wrong with it at the time, or is it because now it advantages the party that now they say that it is wrong? That's the question I'm asking you, as a party, not as necessarily you.
Bernard, let me answer one part of your question, and then leave the other. The part that I'm able to answer is whether or not there's a letter from the party complaining. Bear in mind that the provisions in 97 are essentially to protect the political parties and protect individual constituents who elect their MPs. Now, you ask, what is the difference? The difference is that the political party, in this case, we are not talking only MPP, even NDC itself, with all their mischief, NDC through General Secretary Fifi has not written to Mr. Speaker to complain about Honorable Patrick Aka. The NDC has not issued any public statement to say that it has fired 8 member or 8 member who is going independent has forfeited his membership. The NDC, through its minority leader, Dr. Fawcett, has not issued a statement in Parliament that Mr. Kwacha Umo is no more part of their caucus. So let's get those fundamental things right. As to issues of somebody did something yesterday and all that, I mean, I wouldn't want to go there.
So let me understand that. Does your case, because so the question would be, do you need a letter from a party to trigger what some would consider to be something that's very clear in the way the Constitution is written for the? Of course, we are the untrained mind, right? Does a party need to say, I have sacked you, for us to know that you've left your party? Because there are some things you do that trigger. So, for example, you leave a party and go and stand as a flag bearer of another party. So even if MPP hasn't written to Alan, the fact that Alan is running on the butterfly or whatever as 2024, and the people who have followed him from MPP, they've automatically forfeited. Do you understand? So you don't have to, MPP doesn't have to write to Nano Hinito to say you've left MPP. By the action of going to support Alan, he is out of MPP. And I'm saying that, can you not stretch that to say it's the same thing? Once you've gone to a new party to run on their ticket, there's an automaticity there. You don't need a party to write anything.
It depends on the context. It depends on the context. And I think that the argument must be in context rather than being hypothetical or generalizing. If we generalize it and subject it to a general logic, we may throw ourselves in a state of confusion. But I believe humbly that if we contextualize the argument properly, we can make a great sense out of it. All right? You ask the question whether the political parties need to do any communication. Yes, to some extent and in context, depending on the situation. Like when the NDC wanted to change its leadership, they wrote to the speaker that we as NDC, this is what we want to do. And that speaker recognized this following as our leaders. Similarly, when MPP wanted to do, when MPP took certain decisions at NEC, same was communicated. Now, as a leader, if there is any matter, anybody who is part of my caucus has decided to leave the caucus and all, there will be the need for a communication that I have to receive from the party, and if I have to communicate them to speaker, I must. You see, Bernard, we must allow systems and policies and processes to guide in democracy. If we go by the rule of automaticity, there will be chaos. Otherwise, for instance, when after the election, there will be no need for a formal process of declaration. Somebody will say that I've compared and I've seen that I have 1.5 million votes. Somebody has 1.3 million votes, so I'm the winner. And then the person will declare.
I understand your point, but you see, I'm not over legislating this. But for me, in my recent memory, I remember when Wayoseni crossed carpet. It was a dramatic incident in, I think, 2004. I don't recall a court getting involved. When he crossed carpet, there was a by-election and Inus Afuseni got into parliament. Okay, so the precedent of this cross-carpeting thing that we have seen, this is the first time I'm seeing it's becoming a court issue. It's always been parliament speaker ruling, and then that's the end.
Bernard, I beg you. That's why I said let's just distinguish the facts. The Wayoseni case was a typical carpet crossing. He is an NDC member. On his own, he crosses to NDC MPP and says that makes a pronouncement in the Hansard himself. He says in Parliament that from today, I am no more a member of NDC. I have left NDC and I am going to MPP. Now it gets into the Hansard. I'm saying that if the proper process was followed to trigger a by-election at the time, then it's an opportunity for all of us as a country to bring clarity to the matter. That if in the past nobody really bothered, because I have heard argument that Honorable Rashid Bawa, for instance, Honorable Dick Abubakar Siddiq, who was Salaga South MP at the time, came on as an independent member of parliament, and then Honorable Rashid Bawa, blessed memory, Akan constituency, came on as an independent member of parliament in the 2000 election, and then in 2004 had joined the MPP, and then you hear some senior members saying that, look, when this thing happened, nobody was really bothered and nothing happened. Why is somebody raising all of that and all of that? I'm saying that perhaps if somebody had gone to the Supreme Court for interpretation at the time, they would have established the precedent, which precedent would have guided Professor Quay. But you see, in the midst of confusion, it's an opportunity to straighten things up. So I am very upset, disappointed in what Mr. Speaker Godwin has done. However,
yes,
I am also taking solace in the fact that there's an opportunity to bring clarity on an aspect of our
wonderful.
law.
So your case is important. I have two final questions for you on the fact that your case was made before the Speaker's actions, right? So and from my interview with you, it appears you think the Speaker went out of whatever his order, for want of a better word. So, but basically, you have not questioned his actions in your case. So, are you going to amend that? Because all the points you are raising here will not be in what you've sent to the court. That's point number one. Point number two, your decision to boycott Parliament until the case is heard, is that not going to be injurious to government business? Because we do know that there are a lot of critical issues. For example, this LI 2462 is one of the major promises the president made to the people of Ghana, that he would get his minister to begin the process. So if you are going to be absent from Parliament until that case is heard, and we are not in control of what happens in the courts, will this not injure the business of government irreparably? Yes. Hello, did you get my question, please?
Hello, you can hear?
Yes, I can hear you. Go ahead.
Okay. So, first, we will address the issue that came up yesterday in court. So that's one. The details would be made public at the right time. Second, as it is now, the Speaker has thrown Parliament into total chaos. So the only way is for the court to determine the matter and give direction, so that we are all clear on the path to go. It's not as simple as you say. Those pronouncements that he made yesterday have very direct consequences. And I believe that since he is not ready to engage us, because if he was ready to engage us, we would have arrived at a different result. But it's so clear that all attempts to resolve this intensity have failed. Let's get the right forum to give us guidance. Once that guidance comes, we can make progress. Now, you ask about time. I recall in 2014 thereabout, when the issue of Benjamin Mensah came up, Electoral Commission was going to hold elections in some few days' time. And I took the matter to the Supreme Court. I recall the Supreme Court waived that requirement of notice of 14 days and all, and went ahead to other parties to file their processes. And, there was day-to-day hearing. And within 3 days, my Lord Asukuba, who presided over the panel, made a determination of the matter. I believe that the Supreme Court is aware that this matter is a serious matter on nation building, the governance of the country, the future of the country, and they might have taken judicial notice of it.
I'm
sure whatever happened yesterday, they got to know of it.
All right.
So I expect the judiciary and the Supreme Court to speed up so that they determine the matter. Whichever way they determine it, we all comply and move on as a nation.
Thank you very much for talking to us, Honorable Alexander Afenyo-Markin, Majority Leader.